Okay, so now let's talk a little bit about probate. Remember we talked about wills, and if you have a will, you name a personal representative or an executor, and that will may have to be probated depending on what the assets are. But if there are assets that need to be transferred to the beneficiaries through the will, most likely you'll have to do a probate. Get that person that you've named as the personal representative actually appointed. So what does that involve? Well, most of the time in Minnesota, we have a very, very smooth process for doing this. It's an informal procedure. You file the will with the court, and you file some paperwork with the court that says, I'm the person named, I need to be named, here are all the other beneficiaries that are listed in the will, the other family members, and then you file that with the probate registrar in the county where the decedent resided at the time of his or her death. And that registrar will take a look at all the papers, and they'll tell you that you need to publish notice of the probate, which comes out in very, very tiny print. It was little tiny columns, usually in finance and commerce. I've been told that the Star Tribune is now going to start printing notices of probate. But that's kind of the world's notice that somebody has passed away, someone else has put the will before the court and is asked to be appointed as the personal representative or the executor of the estate. It's also kind of when it starts that creditor's claims period, which is 4 months from the date of publication. So creditors, believe it or not, there are lots of people who go through those probate notices to see whether or not anybody that owes them money has passed away, and they can make a claim against that person's estate. So that's why that process gets started. It is a public process, and sometimes people don't want that to be public. They don't want their will to be filed with the court. They don't want notices to be filed. And so they'll avoid probate by either one, doing some of these things that we're going to talk about down here, beneficiary designations, payable on death, transferable on death, joint tenancy, other forms of property ownership, maybe to avoid that probate process, or they may do something like a living trust, a revocable trust, which is a will substitute, and if used appropriately, can avoid the probate process. Now I've got formal up here, because there is a formal process for probate, and typically, again, the vast majority of these probates move through the informal process. But if there's a problem with the will, if somebody says mom or dad didn't know what they were doing when they signed that, they excluded me and they didn't mean to, the beneficiaries start to fight. Somebody says this person should not be appointed as the personal representative because they've got creditor issues, they filed for bankruptcy, and they're going to take all the money out of the estate. A whole host of issues can throw you in to a formal probate. And then of course, you have hearings. You go before the judge. People get lawyered up. It's a terrible process because eventually what happens is there's no money to pass to the family. Everything gets eaten up in all of these administrative costs and legal costs. So that's something you do want to avoid at all costs. And I think the communication on the front end can help with a lot of those things that pop up on the back end when somebody says, why wasn't I appointed, or why wasn't this done before my mom or my dad or my brother or my sister passed away. So, but that's the probate process. It's mostly informal, fairly easy to get through. So will the estate have to be probated? Well, if it's a simplified estate, and here it's statutorily defined. What is a simplified estate? $75,000 of value or less. That can be, those assets can be transferred through a simplified administration, which is essentially just an affidavit saying, mom owned 2 stocks. They are less than $75,000, and they go to me and my 2 siblings. And you can move assets that way. If it's less than an aggregate value of $75,000, you can do that through a simplified administration. We talked about beneficiary designations. So let's spend a little bit of time on POD and TOD transfers. Okay, POD means payable on death. TOD means transfer on death. So they get to the same result, it's just you use them with different assets. Payable on death designations usually happen with bank accounts. So mom or dad has a checking account or a savings account and they want to make it payable on death to the one child or the two children. They can do that through the bank by filling out a form with the bank saying that payable on death, this money in the account goes to the people that I've listed here. Transfer on death usually happens in a couple different ways. And sometimes they're used interchangeably. But when I think of transfer on death, I'm thinking of real estate and vehicles. So real estate we talked a little bit about, but one of the things that you can do with real estate is you can do a deed right now that says, upon my death, this real estate gets transferred on death to, and it could be an entity, it could be a trust, or it could be to particular beneficiaries. And then you file that with the court, it's filed. You can undo it if you want, you can revoke it, but once you die, that property automatically transfers on death to the individuals that you've specified in the deed, who gets the property at your death. In August of last year, 2017, Minnesota passed a statute that allowed for vehicles to be transferred on death. They have a form now at the Department of Motor Vehicles. You can fill that out and say that if I own this particular vehicle when I die, it can be transferred on death to, and then you can name the beneficiaries on that form. Yes?
Do you have to pay taxes? Like if you sell
No.
the car to somebody?
No, there should not be any kind of registration or any kind of transfer tax at that point, no. No, at the time that it transfers title, yes, probably there might be, but not at the time that you do that paperwork with the Department of Motor Vehicles, because you may sell the car or transfer it. We talked about joint tenancy, other forms of property ownership. We talked a little bit about joint tenancy versus tenants in common versus holding something in your individual name. There are other types of property ownership, but probably beyond maybe the scope of what we want to kind of cover tonight. Okay, I've got a couple examples. This one, Tom Smith, he dies, he has 2 adult children, no spouse, no will. 2 bank accounts equaling $25,000 and an investment account of $30,000. So how are Tom's children going to collect these assets? What do we know that we don't have to have based on what we talked about back here?
We'll go through probate.
Exactly. We're under the $75,000 threshold. So we should be able to collect those assets with an affidavit and a simplified administration process to do that. Okay. Sometimes people think, well, I'm not going to do a will. It's more of a hassle, and I don't have anything. So there's really not going to be anything that's going to go through probate. Well, not having a will doesn't necessarily save you from the probate process. Because if you don't have a will, the state of Minnesota gives you a will. And this is it. When you die without a will, you die what's called intestate, with no will. So if you have property that's not going to pass via beneficiary designation, joint tenancy, payable on death, transferable on death, the state of Minnesota will tell you where that property goes. And this is current statute. If you have children but no spouse, the kids get everything. If you have a spouse but no descendants, the spouse gets everything. If you have a spouse and descendants from both of you and your spouse, the spouse will get everything, with the idea that the spouse is going to take care of the kids. If you have a spouse and descendants from both of you, but the spouse has descendants from another prior relationship, The spouse gets the first $225,000 and half of the balance. And the descendants, which would be descendants of you, the decedent, and the spouse, they get the rest. Thought there is, we don't want surviving spouse cutting out the decedent's kids and giving everything to his or her children from the prior relationship. Spouse and descendants from you and someone other than that spouse, the same situation applies. Again, trying to protect members of the family. If you have no spouse and no kids, but you have parents, then your parents would inherit everything, one or both, depending on who survives. And if you don't have any parents, no spouse, no descendants, no parents, then it would be siblings. And then the siblings would inherit everything. So that's kind of the way that the state of Minnesota lays things out for you. Yes?
I have a friend whose parents have died, her brothers have died, she has no nieces, nephews, children, nothing. Where would she fall there?
Well,
Does that go to the state? Does it go?
It could potentially go to the state.
If she hasn't listed beneficiaries like the symphony or whatever.
Exactly, that's right. Yes, if she hasn't gotten her assets in a form where she can get them directly to the institutions or the people that she wants to have them, then she either needs to have a will to do that, or it's just gonna sit out there, and it'll escheat to the state after so many years. Yep,
Thank you.
yep. The other thing that I just wanna point out, because this happens a lot sometimes when somebody dies and it's a second marriage or a subsequent marriage, and they have not provided for a spouse. They've remarried, but they've left everything in their will to their kids, or they think everything is gonna go to the kids. We have in Minnesota, and many states do, what's called an elective share. And the elective share basically says, we don't want you cutting out your spouse. Now you can do that through a waiver and consent, you can do it through a prenup, and you can do it through a postnuptial agreement. So after you're married, you sit down and you decide, you know what, you have your assets go to your family or your side of the family, I'm gonna have my assets go to mine, let's agree to that. That's called a postnuptial, because it's after you're married. You can do that, but in the absence of any of those, Minnesota provides, states allow for the spouse to make an elective share claim against the estate. So what is the elective share? Well, it consists of two parts. The first part is exempt property, and the second part is a percentage of the decedent's remaining estate. So the exempt property includes the house, if they're living in a house, even if it's not in joint tenancy, if it's just in the decedent's name, the spouse still has right to live in that house for his or her lifetime. One car, and then up to $15,000 of tangible personal property. Then that's the exempt property. There's also something called a family allowance. So if there's a spouse with children, they may be able to put in a claim for a family allowance, meaning this person just passed away, we can't be left destitute. So we're making a claim for a family allowance of a certain amount to come to us each month. And that amount is a maximum of $2,300 a month for up to either a year or 18 months. And the time frame depends upon the situation a little bit. But the $2,300 is not automatic. It is up to whoever is going to be the executor or the personal representative to determine what can the estate afford to pay, and what is it that these folks, the spouse, the surviving family members, children, what is it that they need to live on? So that's exempt property. Percentage of remaining assets in a decedent's estate, that is dependent upon the length of the marriage. If it's married less than, I think, 3 years, 2 or 3 years, it's 3%. If it's married more than 10 years, it's 50. So it's just set out, it's just by statute, is how they determine that elective share. And then we talked about how it could be waived. So it's something to consider, particularly in, situations where somebody has remarried, subsequent relationships, marriages, those are all things that you should be aware of as you think about your estate or planning for your estate, or dealing with somebody in the family who has died, who leaves a surviving spouse. I have an issue right now. It's a family here in Minnesota. Their son died of cancer at the age of, he was less than 50, I think he was 46, 47. He was a Texas resident, but he owned 2 pieces of real estate here in Minnesota. He did have a will, and he was married, no children, and he named his father his personal representative, and he did not leave anything to his wife. He put her down as a beneficiary designation on life insurance, and there was another investment account that was a payable on death, went to her. But in terms of the will and the other assets, there was no provision for her. So what we're dealing with now is an estate that the father is named as the personal representative in Texas, and so there's a probate going on down there, and we're dealing with what are the assets that the spouse may or may not have a right to elect to have some interest in. But up here, we've got these 2 pieces of property, and because they were not either titled correctly or they didn't use a trust, he now has to be subject, the decedent has to have a probate here in Minnesota. So we have to do what's called an ancillary probate to get the father appointed as a personal representative here in Minnesota so that we can get those properties distributed. So it's just a pain. Had there been a little bit more planning and thought on the front end, we maybe could have avoided a lot of that. So if you own real estate outside the state of Minnesota, whether it's a cabin in Wisconsin or a place in Florida or Arizona or Colorado, wherever, that's a red flag to say, I need to be thinking about, do I need to retitle this differently? Should I be using a different kind of estate planning vehicle other than just a will? It's time to have a discussion with Laura or your CPA or somebody that can help you kind of think through those issues. So this client, Virginia Anderson, passed away 10 years ago, age 89, no will and minimal assets. She's survived by 7 children. She spent the last several months of her life living in a nursing home. One of her children, her daughters, lived with her in the house that she owned her whole life and wanted to continue to live there after Virginia died. So she did. It's been 10 years since Virginia's death. Now, the individual, the daughter in the house, wants to sell the house. Problem, house has never been transferred out of Virginia's name to daughter or to anybody else that might have been entitled to it through the intestate part of the estate. So we have an issue now where 2 of the children have now died. So they have children. So how are we going to get this property into its appropriate form so that they can sell the property? Well, what we have to do is something called a decree of descent. But the problem with this is that we not only have the 7 kids, which are now 5, but we have to deal with the 2 deceased siblings' children because they step up now under law. So we've got all these interested parties now that we have to give notice to, that are going to have a say in this administration. And of course, they can't decide who should be appointed as the administrator of the estate because they're all kind of bickering and fighting about who the appropriate person is. The other potential issue we have here is that with Virginia spending time in a nursing home, that raises the issue of medical assistance and whether or not she received any medical assistance. And if she did receive any medical assistance, you can darn well bet the county has a lien and a claim on that property. So now you've got a medical assistance lien that you have to get clearance and you have to waive, and they're gonna want their money out of the sale of that house before anything else goes to any of the beneficiaries. So real estate can pose a lot of different issues. It really poses issues when people don't think they have to do anything with it, and then they wait. And what happens is usually the problem gets bigger and bigger, and it kind of mushrooms, and it can be a real pain for the family.
In a case like that, can a court appoint an executor?
Yes, and that's exactly what they do. And what you hope for is that everybody can agree to who that person will be. Because then you can just go in and say,
But it could be someone not in the family.
it could be, yes, if all the family members agreed to it and said, you know, we can't agree among ourselves who's gonna be appointed, so let's get somebody neutral, and then we can all agree to
Right.
that. Yes, you can do that, and you can do that with nominations and appointments that the family would,
What a mess.
yeah, that the family would fill out.
Mhm.
So the last little thing on your, I'm gonna flip back to your checklist here for just a minute. And this is just kind of something to consider for surviving spouse. We kind of did this just for the surviving spouse, but it really could be for anybody after there's a death in the family. I mean, that really is a good time to pull out your own documents, to meet with your advisors, to say, hey, my brother just died, and I think I might have named him as guardians for my kids, or he's named as my personal representative. So, or I got him down as a beneficiary on an IRA account I have. So those are all good times to think about updating your own documents and your own assets and considering beneficiary designations and titling of assets as well. So I think I just have a couple examples left, and then we'll be done and we can open it up for questions. But in this example, John and Jane died tragically in a car accident together. They have 3 children, and all the children are minors, under age 18. They do have wills. The wills name the guardians for their children, and they provide for a trust, a contingent trust for the benefit of the kids. Kids get all the assets, but guardians are going to be trustees, and they're going to manage those assets until the kids attain the age of 30, and then that's when they can be paid out to them. The majority of the financial assets, however, are in IRA accounts and life insurance death benefits, and lo and behold, beneficiary designation says all to my spouse, and if my spouse doesn't survive me, to my kids. Problem, they're not going to pay money to minors. So now we have to say, okay, is there a way that the institutions holding those assets, the life insurance company, the financial institutions, will they be willing to pay it into this contingent trust that they meant to set up? I mean, they did set it up in their wills, but they meant to get it into the wills, into the trust through the wills by the beneficiary designation, and they just didn't do it. They didn't coordinate their beneficiary designations with their estate plan. So will they be willing to pay that into this trust? Maybe, maybe not. If not, we have to go and we gotta get conservatorship set up for each of the kids, for the kids, until they're age 18, or the court sometimes will allow for a protective order, which means that the money basically goes into a protective custodial account, kind of sitting there, until the kids reach age 18, at which time then they can get it free and clear, because now they're at the age of majority. So the problem here is, one, leaving assets to minors. That is a problem in and of itself. And two, and the more unfortunate problem in this case, is that they actually had the right estate plan. They just didn't coordinate the assets and the beneficiary designations to make sure that it would be in line with their estate plan. Very simple solutions. They should have just changed the beneficiary designation to say, instead of the kids, it should say the trustee under my last will and testament. And then it would have gone into the trust for the benefit of the kids. So it's just another good example of, once those documents get done, throwing them into a safe deposit box or a safe, you've got to take that next step to make sure you're meeting with your financial advisor, the people that are working with you, to say, okay, this is how I've got my estate set up. Are my assets in line? Is everything coordinated with the plan that I've put in place in my documents? I think that's it. I think these are some general resources that we included on the back page of your checklist. And that concludes kind of the formal presentation. Does anybody have any questions? Yeah?
What would happen with personal furnishings, art, jewelry, that sort of thing?
That's a great question. It's a great question because, believe it or not, and I've worked on small estates and I've worked on very large estates. And it doesn't matter what size the estate is in terms of monetary value, the biggest squabbles come over tangible personal property. So, yeah, just a lot of emotion, a lot of sentimental value. So a couple things on that. One is that Minnesota law allows you to do a separate personal tangible property list, separate and apart from your will or your trust. And you can designate on that list what item of personal property you have and who it should go to. And you can change that list anytime you want. That's something, you don't need a lawyer to do it, you don't need any fancy language. You do have to adequately describe the item and then indicate who it goes to. So that's one way to take care of it. The other way to take care of it is to talk to your family beforehand. You know, I can't even tell you how many times there's so much resentment that gets built up if somebody gets something that someone else thought they should have, or that mom or dad would have wanted them to have. I mean, it's just unbelievable, whether it's a toolbox or, a piece of jewelry or whatever it is. I just encourage people, if you can, if you've got the family dynamics, ask them what it is, what is it that you would like? What would be meaningful to you? Or if you're gonna do that, think about what might be meaningful to somebody. They may not want it. That's their choice. You're gone. But if you can say, the reason I gave this to you is because I bought this on the trip when we were over in Italy together and da-da-da-da. That's meaningful to somebody, and they understand why, the other family members can understand why, Susie got the wedding ring and I just got the diamond necklace or something like that. I mean, I think the communication, again, is very helpful. Now, when there isn't any of that, and you've got a house full of tangible personal property, and somebody's worried about somebody else swooping in and grabbing everything, there are processes that I've seen used that work well. Sometimes it's everybody throws their name in a hat, and the first person, you pull out, and then you have an order of people go around and pick stuff. Sometimes it's everybody goes through the house and they stick certain colored stickers on things. And sometimes there's nothing that 2 people wanted or 3 people wanted. Sometimes there's a few things that more than one person wanted, and then you have to kind of figure out a way to deal with that. So there's ways to deal with it, but I think just having the discussion up front, thinking about it up front. On the flip side of it, I will tell you, I've had people say, I don't know why they left me all this stuff. I don't want any of this stuff. It's more of a hassle for me. And I think that's hurtful too. I mean, I'm almost like, well, take something to remember your family member by. Or if they offer something to you, take it. It makes them feel good. It makes them feel like you valued it. They obviously valued it if they wanted to give it to you. So those discussions, I mean, Laura, you probably deal with this with families or with clients too sometimes, just the discussions about, what do I do with this stuff? How do I deal with it? But it can be a real source of anxiety for families, this tangible personal property. So.
Just a comment, we sold our home 2 years ago, moved into a senior apartment. And the 4 people most happy about it were our children. Thank you, Mom and Dad, for doing this.
Yeah.
Because we won't have to deal with it later, huh?
That does not surprise me.
Yeah.
One other thing, the children took many of the things from the house. And I said, how are we going to equalize this? They gave us the best gift ever. They said, don't worry about it, we don't care.
Yeah. And a lot of times those things that are causing you anxiety really aren't things that they're concerned about at all.
We got it settled beforehand.
Yeah.
Exactly. That's the key. Yeah. Equality and fairness don't always, there's a difference there sometimes, and you kind of have to walk through what people are talking about when they say equal or fair and that kind of thing, so. Well, with that, I've gone over a little bit, so I apologize if there's no other questions. I think I'll turn it back over to Laura.
Thank you.